needed in this crucial time when the world as we know it has wobbled badly due to a virus, and the nation is in turmoil with so many people asking, is the judiciary fulfilling its role as sentinel on the Kiwi? Our trustee and former election commissioner, Mr. T.S. Krishnamurthy, has so kindly agreed to preside over today's program. I would like to thank him for persuading Justice Venkatachaliah to accept our invitation. We are grateful to Madam Indira Jaising and Justice A.K. Sikri for their willingness to add heft and luster to today's program with their formidable experience at the bar and the bench. A word about Moneylife Foundation's RTI Center. We work at educating and empowering people to use the RTI Act effectively. We're able to do this due to the support and participation of some of India's best known and most dedicated RTI activists. I'm delighted that so many of them are here today. The RTI Center was established because of the gracious support of Mr. Dinesh Thakur, who's also here with us today from the US, who's globally renowned as the whistleblower who exposed Ranbaxy's dubious testing methods. His foundation supports a host of healthcare and RTI initiatives in India. A big thank you to our media partners, Free Press Journal, Bar and Bench, and the Leaflet for being our partners at today's program. Before I invite Mr. Krishnamurthy to take over today's program, some quick ground rules. Except our speakers, everybody else will be in mute. For best viewing, we recommend you put yourself in active speaker mode. You can use the chat facility to communicate with us during the session. If you click the red raised hand button, we know you have a question. This will be during the discussion that follows. And this program is recorded. It will be available on Moneylife's YouTube channel. It's also being live streamed on Facebook. If you want to protect your privacy, we suggest you turn off your video at home so that your background is not visible to everybody. I now have the honor and the pleasure of handing over this program to Mr. Krishnamurthy.
Very good evening to all of you. First of all, let me thank Mr. Justice Venkatachaliah for being with us. It's a pleasure and a privilege to be associated with him. I have known him from year 2000 when I was in the secretary in the Department of Company Affairs. His contribution to the strengthening of the quality of judiciary in this country cannot be overemphasized, and his nation's pride. That's what I always say. And I'm glad that he has accepted our request to give this third RTI lecture for the Moneylife Foundation. He is a true believer in judicial accountability. He has often said that judiciary should be subject to any criticism and should be able to face them and make the judges should be more accountable to the public. The way in which he conducted himself, not only in the Supreme Court but also thereafter in the Human Rights Commission, it's all very well appreciated. He's not only brilliant, age has not withered his brilliance, yet nor custom style his infinite variety or talents. He is keeping himself updated with latest developments in every field, not only in judiciary, but in other areas. It has always been a pleasure to hear him. I am glad that he accepted this invitation to give this lecture. He has been awarded with many national honors, including Padma Vibhushan. But what is more important is humility. I have never seen a person more humble than Mr. Justice Venkatachaliah, in spite of not only his integrity and his knowledge, but also his remarkable interpersonal relationship. We are grateful to you, sir, for being with us today, and we are looking forward to your lecture. Thank you very much.
Esteemed Sri Krishnamurthy ji, Mas Sucheta Dalal, ladies and gentlemen, I am deeply sensible of the honor of this invitation. The RTI lectures of the Moneylife Foundation have acquired a high reputation. The galaxy of earlier speakers is intellectually intimidating. I'm here because I could not disobey my esteemed friend, Sri T.S. Krishnamurthy ji, who has a splendid record both as an acclaimed administrator and as the Chief Election Commissioner of the nation. When the first controlled nuclear fission was achieved at Los Alamos, Albert Einstein exhorted, everything changed. The world has to adopt a different line of thinking if it is to survive. In the COVID world, everything has changed again. COVID pandemic has changed everything. What will the post-COVID world be like? The leaders of the world must sit down, take a deep breath, and formulate what the post-COVID world needs. A broad sense of humanism and human welfare and human survival must inform that debate. Imagine a world where just 4 richest persons own wealth equivalent to 4 billion poor of the world. Our country is a beautiful land with breathtaking scenic beauty, great mountains, rivers, lakes, ocean, and a large share of the flowering plants of the world, and an equable weather, 12 hours of night and 12 hours of day. The envy of many of the northern states. Human life can be happy if only those who preside over their destiny can let it happen. People must be emancipated from the curse of corruption and inefficiency. In the next 45 minutes or so, I propose to share with you, or rather place before you, some thoughts of a 92-year-old extinguished judge on what Indian judiciary has done to promote what the Indian judiciary has done to promote the egalitarian philosophy of the Constitution, to protect individual liberty, and the philosophy of legal control of government. The expression qui vive was first introduced into the constitutional parlance by Justice Patanjali Shastri in the famous case of V.G. Rao back in the year 1952. It expresses the constitutional philosophy of checks and balances. It simply means this: the structure of government should be so designed that each branch is a sentinel on the qui vive against the other two, lest they become too powerful or too autocratic. No constitution works by itself. It needs the instruments of the common law, legislation, and constitutional conventions. That's a very, very important thing. There is symbolism in constitutional expressions. For instance, Article 53(1) of the Constitution proclaims that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. This is an impressive statement, but it has just one defect in it, literally understood. The position is exactly the opposite of what it conveys. The President, except in some special situations, must act only on the advice of his Council of Ministers. Inviting the leader of the Parliament to form the government may be one exception. Rashtrapati Bhavan is not, to borrow the expression of Justice Krishnaiyer, Rashtrapati Bhavan is not a halfway house between the White House and the Buckingham Palace. This is not the Potomac, but the Thames that fertilizes the flow of the Yamuna. On this issue of the power of the President, there are some serious arguments and differences between the then President, Dr. Rajendra Prasad, and Prime Minister Nehru. Dr. Rajendra Prasad said he is not the British Queen, but an elected Indian President. Supreme Court later had to laid this argument to rest. The interrogative title of this talk has a veiled, though not explicit, message that the judicial wing of the state might not be doing enough. The judiciary in the classical mold of an adversarial system is just an umpire, as in the game of cricket. It still is, but great changes have occurred within the system. It is the advent of the public law principles that has changed the system and changed the judge from the position of a mere umpire into something more important and more significant. It is the advent of the public law principles that has brought about this change. A feudal society is grimly struggling to break away from the shackles of a tyrannical feudal social order and transforming itself and reborn into a modern egalitarian industrial society. Making of the Indian Constitution was an inspiring historic spiritual event. It was not a mere political event. That was at the end of the World War II, in which barbarous inhumanity and cruelty was exhibited. India's partition itself witnessed killings on an enormous scale on communal differences. In this context, the debates in the Constituent Assembly rose to spiritual heights in its concern to lay future foundation for a new social order based on respect for human life and to save the posterity from the scourge of communalism. The great diverse cities had to be accommodated. Imagine even the right of a person professing the Sikh faith to carry a kripan had to be expressly accommodated in the constitutional document. Even so, it was the genius of great judges to develop and nurture new judicial philosophy to aid the constitutional vision of a new egalitarian order and shape the architecture of an inclusive society. In this endeavor, the role of the Constitutional Court came to the forefront. Traditional threshold limitations on the entry to the courtroom had to be relaxed. We call it the locus standi. If a person did not have a direct personal interest in the subject matter of the litigation, he would be termed a mere meddlesome interloper or a busybody. But the poor and the marginalized whose interests were affected had no educational or financial means to access justice by themselves. Therefore, the threshold bar or locus standi had to be relaxed. That was done by a great act of judicial statesmanship. The second equally important transformation was of the role of the judge himself, no longer a mere umpire. He assumed the conceptual role of one who, quoting Upendra Bakshi, I say, who firmly anchors adjudicative leadership of the nation as an integral judicial duty towards the people of India and reinstall the concept of judicial power as an aspect of judicial duty. This is the most important transformation of the role perception of the judge in public law. Thirdly, the court had to fashion new tools for legal control of government. Every action of government had to have a legal pedigree. Court successfully enlarged the concept of state to include its instrumentalities and agencies, developing new legal algorithms for holding them down to the duties and responsibilities toward the people. Protect and promote democracy and democratic traditions, protect environment, protect the vulnerable sections, women, children, prisoners, under trials, develop principles guiding the liability of those who store and use intrinsically dangerous substances, such as poisonous gas, etc., and develop absolute and not mere strict liability principles. All these are fascinating stories. We shall now get a short glimpse of them. Ladies and gentlemen, the public law administration lawyers and the areas they chose assisted the court to develop new instruments of legal control of government. Principles of constitutional morality and doctrine of manifest arbitration are some of these ideas developed by the court. But in actual working, they may present some difficulties and problems. They just do make law. The photographic theory, as it is called, of the judicial function, that a judge is merely to find the law as it is and the lawmaking function does not belong to him, in the final analysis, is not a tenable theory. The nature of the judicial process itself is creative of the law. Doctrine of precedent makes it one judgment, one swallow will make the summer, and it will rule the roost in the next cases. There was never more sterile debate, said Lord Reed, that judges don't make law. Judges do make law. And he said, we do not believe in fairy tales anymore. Particularly impressive is the activism in the area of environmental protection, rehabilitation of the Doon Valley. Actually, after the mining there, it was a devastation. But the new rehabilitated Doon Valley is as flush, or perhaps more flush, more lush than what it was before. The Doon Valley, Aravalli Range are just some instances. The public interest litigation, epistolary jurisdiction, and the innovation of the appointment of commissioners and amicus curiae are extraordinary exploits of a new judicial era. As sentinel, there are great cases that illustrate the chained role of the court as sentinel, as a Kiwi. Keshwananda, Satwant Singh is a passport case. Bandhwa Mukti Morcha, where they expanded the locus standi. Banwasi Seva Ashram, Ajay Hasya, Airport Authority, Royappa, Sunil Batra, Bachan Singh, Idiga Annamma, Neelabati Behera, Husainara Khatun, Vishaka, in Kerala Education Bill, Joginder Kumar, D.K. Basu, Nandini Satpathy, Gamsi Mehta, Maneka Gandhi, Motilal Padampat, Olga Tellis, and many, many others which have blazed this trail. Vishaka case raised an interesting question of far-reaching significance as to what extent international covenants can be read into domestic laws. Ladies and gentlemen, most important transformation that came imperceptibly like twilight opening into daylight. The individual, the adversarial legal system transformed itself into an inquisitorial system in public law. This is one of the most important changes in the philosophy of the judiciary itself. This is the cornerstone for all the other judicial exploits in the field of the role of the court as a sentinel, the key of the constitutional values. India is an ancient, and some critics say that India is an ancient, great civilization in an advanced state of decay. They say it lives concurrently in several centuries, both past, present, and future. But there is no denying the grandeur of its legacy, both culturally and politically. Ancient India was studded with republics, from Emperor Ashoka to Mahatma Gandhi. The recurrent theme of society was the celebration of human dignity and humanity, and celebration of the conscience of mankind. Long ago, someone described India as a functioning anarchy. The Global Competitiveness Report said that India is third in the world in the matter of availability of scientific talent, fourth in the world in the size of its domestic market, and fifth in the world in its potential to access international markets. But in India's overall competitiveness was placed at 50. But it's true that India is in the forefront of nations achieving economic breakthrough, not by exhausting their natural resources or by the raw muscle power of the factory, but by the brain power as a catalyst of progress. When India declared universal adult franchise and parliamentary democracy at the advent of its independence, the Western press was cynical about its success. They said, how can 330 million ignorant, uneducated people manage a government of Westminster model with such sophistication? It was called the biggest gamble in history. But the same press, 60 years later, in 2007 called the Indian democracy robust, though described as the rowdiest democracy. The origin of political democracy dates back to the 18th century, where it took roots as a form of governance in Great Britain. In 1865, a liberal statesman, John Bright, in his speech to support the electoral reform in England, called England the mother of all parliaments. This term was coined owing to the adoption of the Westminster model of parliamentary democracy by many countries of the former British Empire. Since then, the concept of parliamentary democracy has spread across many nations through ages. The need for social organization of man stems from the fact that all human beings, incomplete in themselves, seek the ordainment of their destiny and their fulfillment in the enriching atmosphere of human companionship and political institutions. Democracy provides the richest and the most profound opportunities for this mutual enrichment. It is intended to provide the best opportunity for each member of the political society to achieve and bring out the best in him. Democracy is not the best form of government, but it is the least hostile amongst all the systems tried so far. When somebody said that in a democracy, people get the government they deserve, Bernard Shaw embellished it by saying that democracy is a system that ensures that people don't get a better government than they deserve. John Stuart Mill points out, I earlier said, that man's capacity for justice, according to Reinhold Niebuhr, makes democracy possible, but man's inclination to injustice makes democracy necessary. John Stuart Mill points out the first element of good government, therefore, being the virtue and intelligence of the human beings composing the community. The most important point of excellence which any form of government can possess is to promote the virtue and intelligence of the people themselves. In the unforgettable words of Justice Frankfurter, democracy involves hardship of the unceasing responsibility of every citizen. That's why no office in the land is more important than that of being a citizen. The protection of democratic values in the conscience of the civil society, which should control the political society. Civil society must control the political society. If the civil society itself is fractured and fragmented and consists of groups in perpetual conflict with each other, then the political society will have ample opportunity to manipulate the groups and set up one against the other. Constitutional democracy is one where the majority will and rule is controlled and directed by constitutional principles. For otherwise, it will sooner or later degenerate into elective despotism and then mobocracy. Without constitutionalism, only the husk of democracy remains, and democracy becomes a mere statistical interpretation of numbers. Dr. Ambedkar, it's a very important statement that he made. Dr. Ambedkar, speaking in the Constitutional Assembly, referred to Grote, the Greek historian. The diffusion of constitutional morality, not merely among the majority of the community, but throughout the whole, is the indispensable condition of a government at once free and peaceable. By constitutional morality, Grote meant a paramount reverence for the forms of the Constitution, enforcing obedience to the authority acting under and within those forms, yet combined with the habit of open speech, of action subject only to different legal control. Dr. Ambedkar went on to say that this is a very, very important point which I wish to convey. This is very usually overly forgotten. Ambedkar went on to say, the form of administration, the way we administer, has a close connection with the form of the Constitution, and it is perfectly possible to pervert the Constitution without changing its form, or merely changing the form of administration, and to make it inconsistent, opposed to the spirit of the Constitution. This is exactly what is happening in the country. As someone in the old days said, that he preferred Russian laws enforced with English procedure to English laws with Russian procedure. We can have democracy, or we can have concentration of wealth in the hands of a few. We cannot have both. We can have democracy, or we can have concentration of wealth in the hands of a few. We cannot have both. But the profound observation by Louis Brandeis in relation to India, this cliche comes home with strange poignance. The Universal Declaration of Human Rights of 1948 has made election and democracy synonymous. And democracy with election, human rights and democracy are concomitants, inevitable concomitants, and democracy and elections are concomitants. That's a very interesting but debatable position. The will of the people shall be the basis of authority of the government. Of course, that's the principle of democracy. This will be expressed in periodic and genuine elections, which shall be by universal and equal suffrage, and shall be held by secret vote or by equal and free voting procedure. So, outcome of an election is by definition made equivalent to democracy. But there are certain views which are very interesting, again, to say that this is too sweeping a generalization. Walter Lippmann, in his work called the Phantom Republic, made some profound observations. The justification of majority rule in politics, is not to be found in its ethical superiority. There is no ethical foundation for this assumption. It is to be found in the sheer necessity of finding a place in a civilized society for the force which resides in the weight or numbers. A beautiful thing. This is a compromise made to recognize the weight of numbers and give it a dignified political stature. Elections based on majority rule can be understood as sublimated and denatured civil war, a paper mobilization without physical violence. Look at this. Walter Lippmann characterizes identification of the functioning of the government with the will of the people as a fiction, as the intricate business of framing laws and of administering them through several hundred public officials is in no sense the act of the voters, nor a transition of their will. Implicit in the idea of a representative democracy are the notion of a filter and a microcosm. In a mass society, it is regarded as not only necessary, but also a positive benefit that the volatile nature of raw public opinion should be refined through an electoral filter that gives representatives the opportunity to deliberate and exercise their judgments, free from the factional interest or majority intolerance. By the same token, a representative democracy has to approximate closely to the society it seeks to represent in order to maintain its legitimacy as system of government. It's a very profound idea. There is a perceptible democratic fatigue all over the world. I call it a democratic fatigue. Various surveys around the world showed considerable increase in calls for a strong leader who does not have to bother with parliament and elections, and that trust in governments and political parties has reached a historical low. This is a pendulum effect, as they call it. You go to the other end, you think the next opposite end is the safe haven. This is the kind of a public mind. And that trust in governments and political parties has reached a historical low. It appears that people like the idea of democracy, but loathe the reality. They love the idea, but loathe the result. Political parties are among the most distrusted institutions in society. But then the idea of a benevolent dictator is a contradiction in terms itself. And there is no substitute for democracy. It is said of Sir Winston Churchill. He said democracy is the worst form of government, except for all other systems we have tried so far. And E.B. White said, it is based on the recurrent suspicion that more than half of the people are right more than half the time. It's a very interesting question that you put. But then the inverse proportion between the vote share, the two systems of, we know that there are two systems of election. One is the first past the post system and the other proportional representation. All others are combinations of the two in some proportions or the other. As to the system of proportional representation, Pandit Nehru, in an interview with Michael Becher, said, I think of nothing more conducive to creating a feeble ministry and a feeble government than this proposal of proportional representation. But imagine in 2014 election, if I remember right, in the 2014 general election, Bahujan Samaj Party got the third largest vote share in the country. But they didn't win even one seat. They got the third largest vote share. Parties which got much lesser vote share had number of seats in parliament. This is an anomaly which is inherent in this system. And ladies and gentlemen, coming to the point of our court as sentinel of the Kiwi, constitutional mandate of personal liberty in the early years saw a judicial reluctance to give up to it. There's a very interesting debate. For example, a man was to be detained. If the Home Secretary in England, they said, if the Home Secretary is satisfied that in order to protect public order and public safety, detention is necessary, a person could be detained. That's the famous liver siege case way back in the 1940s, I think 1942, during the wartime. The Home Secretary filed an affidavit, I am in fact satisfied. The majority, the court majority of the court in the House of Lords said, all that law requires is that he must be satisfied. He says he is satisfied. Lord Atkin entered a shattering dissent. He says, subject to satisfaction, all right. The court would seek objective tests of such subjective satisfaction. And Lord Atkin entered a shattering dissent. And the aftermath of it was a little strange even in England. Judges, in fact, that judgment of the majority was later on criticized by English jurists themselves. They cynically said it is at best the judge's contribution to war effort. And now we have placed it where it belongs, in the War Museum. Lord Atkin, who entered the dissent in liver siege, was later celebrated as a great judge. Same thing happened in India in the first case, in the H.A. Gopalan case, the personal liberty case. The Constitution, Article 21 says, no person shall be denied life or liberty except in accordance with procedure established by law. Procedure established by law. There are law made for preventive detention. Great 5 judges of the Supreme Court, Justice Fazl Ali dissenting, they said that there is a law. And as long as there is a law, there is no question of our deterring and not upholding the detention. They said procedure established by law virtually degenerated itself in the hands of the court to procedure prescribed by the legislature. Is there a difference between procedure established by law on the one side and procedure prescribed by the legislature on the one side? And the judges said, if the law said, they went on to rub the point in by saying, if the law said the clerk of the Bishop of Rochester should be boiled in oil, if the law said that, so be it. The ethical quality of what qualifies to be law was not gone into. And that was the later debate 27 years later in the Supreme Court, in the Maneka Gandhi case, said that this is not law. First thing is what it takes for a resolution of the legislation to be called law. What are the moral and ethical content of it? And that was the great debate. And that's the starting point. Gopalan was the first embarrassment to the libertarian court. There are two cases, ADM Jabalpur and Gopalan, two perhaps cases which both of them were overruled promptly. But when they were made, the court took a very dim view of the glory of concept of personal liberty. To rub in the point, the judge said, if the law required that the cook of the Bishop of Rochester be boiled in oil, so be it. This view was overruled 26 years later on. The constitution making in India coincided with the post-war thinking on the need for a universal declaration of human rights. Our fundamental rights discourse was greatly influenced by the post-Second World War contemplations and the need to protect humanity from the scourge of such human conditions. In the development discourse, there are two rival theories. One sees economic development as a fierce process which ignores everything, even social interests, which might come in the way. The other theory sees the development process as a more friendly process and sees social reform as the spur and not merely the result of the process. This is a great debate. There is I'm told, a great thesis called the Lee thesis. Lee Kuan Yew, the builder of modern Singapore, he seems to have believed that democracy and development don't go together. If you want development, suppress, no need for overemphasizing democracy. You have democracy, perhaps you may not have development. This is the famous Lee thesis. Virtually after there is a story said about how the committee headed by Eleanor Roosevelt to formulate Universal Declaration of Human Rights. I think India was represented by a lady member, Hansa Mehta. I think it was related to Jivraj Mehta of Gujarat. That took its own time. And ultimately, on the 10th of December 1948, the Third General Assembly adopted the Universal Declaration of Human Rights. By a felicitous coincidence, exactly 20 years later, on the 10th of December 1968, Professor René Cassin, who was the chief draftsman, the French internationalist, who was the draftsman of the committee, a member of the committee and draftsman, was conferred a Nobel Prize for Peace. Somebody on that occasion asked him, Professor, why does humanity need a universal declaration of human rights? In perhaps the greatest understatement of the century, the professor said, we need a declaration of human rights because men are not always good. Men are not always good could be an epitaph on the grave of the 20th century, where we have killed perhaps 230 million people, 100 and odd million in wars, and the rest in civil strifes, not unconnected with racism, language, linguistic differences, and many differences that separate man from man. And it's also interestingly said that Eleanor Roosevelt, the chairman of that committee, which had to struggle, there was a lot of opposition and discussion, took a long time. She had kept a bottle of champagne to celebrate the signing of the recommendations. It was so delayed that when she opened the bottle of champagne, wine had turned into vinegar. It had gone sour. And she exclaimed that if a bottle of human rights were long, they turn sour. That is the story of the human rights. Ladies and gentlemen, I'll take a little refer to some interesting cases which we have dealt with. I hope after the judicial debacle in Gopalan came the fresh breeze in Maneka. In fact, it is debated in the Maneka case, there was no cause surviving in the Supreme Court at all. The passport had been granted, and there was no list pending in the Supreme Court. Supreme Court took the opportunity. There was no fight at all. The government agreed to grant the passport. But even so, the court said, we will not lay down the law. They said, without a cause, you are laying down a law. But that's a different matter. But the content of the judgment is the most relevant thing. After the judicial debacle in Gopalan came the fresh breeze in Maneka. The case of the under trial prisoners was yet another classic judicial exploration of the great humanism permeating penology. The echoes of Idiga Annamma, she was awarded a death sentence, and the Supreme Court interfered. And the echoes of Idiga, that famous case, was heard in the English courts. Lord Scarman and Lord Brightman in the Privy Council in the case of Noel Rowley versus Attorney General referred to this Indian precedent. Satwan Singh was yet another landmark exercise in the right to free movement. The innovation of public interest litigation was an act of judicial genius. The restriction of the old order on access to courts were removed, and some of the great strides in ameliorative judicial intervention changed the face of the law. Conventional shackles and fetters of formalism were removed. The court developed tools for legal control of government. In a series, in this general, we find a series of cases such as Kusanara Khato, Sunil Batra, Nandini Satpathy, Bombay Hawkers case, Rayappa, Ramana, Vishaka, protection of women in workplaces, and many other socially oriented themes. As to the response of the other common law jurisdictions to the Indian judicial innovation, Andhyarjuna, a learned lawyer, in an invited article in the Law Quarterly Review says, the beneficial nature of this easy approach to courts, I'm quoting from Mr. Andhyarjuna, the beneficial nature of this easy approach to courts by disregarding the conventional requirements of local standard of the applicant and the non-adversarial character of the court's intervention. It became virtually inquisitorial court. Came to be widely appreciated by the public and even imitated by other common law jurisdictions. It was applauded by distinguished judges abroad. Justice Michael Kirby of the High Court of Australia said that the Indian Supreme Court and the High Courts had been particularly creative and imaginative in this kind of jurisprudence. Lord Chief Justice of England and Wales, Lord Wolfe, confessed to having been astounded at first by the provocative approach of the Indian Supreme Court in these and other respects. However, he went on to say, I soon realized that if that court was to perform its essential role in Indian society, it had no option but to adopt the course it did, and I congratulate it for the courage it has shown. Of course, courts have recognized limitations on their power of judicial lawmaking or in the absence of judicially manageable standards, or on the grounds of political tickets. Judicial activism can at times run against the doctrine of judicial restraint. Many judicial interventions may not present judicially manageable standards and lack adjudicative disposition. They may answer an urgent human need, but a faint crack develops in the foundations of our system of government. A judge begins to rule where only a legislator can. It is only weak societies that constantly appeal to judicial paternalism to solve its problems. Such a weak society loses the excitement of democracy to fight issues out democratically. That is the hour of a court's temptation. Judicial activism can be a slippery slope. Generally, policy issues are a different and difficult area for judicial penetration. public policy, Lord Denning once said, is an unruly horse, but it is for a able and competent judge to ride that unruly horse and bring it down on the side of justice. But I don't know how many of our judges are good horsemen at that. But one thing we must understand. Judiciary does not have enough stock of social economic wisdom to say whether the law is wise or otherwise. That's what a great judge exhorted. He said, all that I want is what the crowd wants. American Supreme Court, in dealing with the power under the due process clause, did extraordinarily unpopular things. They struck down paper currency, issue of paper currency, they struck it down. They said you can't issue paper, the gold standard and all that. And when the legislature, the American legislature prescribed working hours for bakery employees who work in oven, before oven set up working hours, they struck it down by saying that it interferes with the free labor contract. If a person agrees to work for 24 hours a day, well, it's his choice. We can't get into it and interfere with some of these things. In fact, the steel mills were taken over. Millions of dollars are spent on their improvement during World War time. After the war, court said, give it back to the owners. And there are many, many things which happened. And so much so that ultimately they became the super legislature, the third house, as we call it here, and the super legislature in America. And after the Great Depression, then the New Deal legislation came in. In 1963, officially, in a case called Ferguson versus Krupa, the American Supreme Court said, we are tired of acting the super legislature. We must stop doing that. And they recognized it. They recognized the limitations and then said, and the great Edwin Corwin, a constitutional writer and authority, he introduced a chapter, The Demise of the Due Process, in his book. Instances of monitoring, prosecutions, and investigations in case of corruption, overseeing legislative proceedings, as we have said, whether voting is proper in the legislature, fall into a very difficult class of judicial work. Right or wrong, it may serve an immediate purpose, but what it may mean in terms of the balance of powers may be a different argument. In fact, in the appointment of judges case, Lord Robin Cook, who was the House of Lords, was also, I think, Chief Justice in New Zealand. He said something. He said, first article he wrote was where angels were to tread. Was the first part, full session, he didn't say, fortunately, where angels were to tread. He said, the majority of the court may have gone too far in commenting on the Indian court, too far, if their conclusions be viewed as an interpretation of the Constitution intended to be binding in law. However, vulnerable in detail, it will surely always be seen as a dramatic event in the international history of jurisprudence. There is an element of sarcasm in this language. Later on, he said, when the angels weep, he wrote an article called Where Angels Weep. He said it sounds more like a promulgation of policy than an exercise in juridical reasoning. Reasoning is noticeably limited. See the language. The reasoning is noticeably limited. All in all, the opinion of the Supreme Court in the third judge's case must be most remarkable ruling ever issued by a Supreme Court, by a Supreme National Appellate Court in the common law world. He expressed his surprise. In the context of such expansive judicial mood, the caution of Justice Harlan Stone of U.S. Supreme Court is worth recalling. I quote, "This court, no less than all other branches of the government, is bound by the Constitution. The Constitution does not confer on the court blanket authority to step into every situation where the political branch might be brought to have might be thought to have fallen short. The stability of this institution ultimately depends not only upon it being alert to keep the other branches of the government within constitutional bounds, but equally upon recognition that the limitation of the court's own functions in the constitutional system. This is another sentinel, the key upon itself, its own limitation. Each branch trying to introspect and say, find out what are its limitations is a part of the key on the alert. That is also the role of the sentinel of the key. A sternal warning of Justice Jackson at the American Supreme Court reads like this: doctrine of judicial activism, which justifies easy and constant readiness to set aside decisions of other branches of government, is wholly incompatible with the faith in democracy, and insofar it encourages a belief that judges should be left to correct the result of public indifference itself is a vicious teaching. You can't interfere in the other branches of business unless there's a legal justification. In the USA, the due process clause was used to strike down issues of paper currency, regulating working hours, order and return of steel mills acquired during the war. There are criticisms that the courts have ignored highways and sought bylanes of justice. The courts, however, must not ignore the caution that every judicial decision has to be reasoned out. It has to be arrived at with logical coherence and political neutrality. Ultimately, the court, the American Supreme Court admitted it was going too far. In Ferguson v. Scoop, declared that it would no longer act as the super legislature. Another, Edwin Corwin added a chapter called The Demise of the Due Process. Justice Holmes, in his inimitable way, he said, United States of America will not come to an end if judicial review is taken away. And he is the one who said, I don't have the stock of social and economic wisdom. All that I want is what the crowd wants. Great that. Ladies and gentlemen, I've taken a lot of your time to say some philosophical underpinnings of this thing. In even the human rights itself, in the evolution of political organization of men, there has been a continuous yearning for a higher law as a touchstone for the ethical and moral content of rules of possible law. Parliament can make law, but are there any ethical limits of the lawmaking? Written constitutions are intended to realize this aspiration. It seeks to avoid the concentration of power by built-in checks and balances and constitutes the foundations of the legal system. This is the sentinel of the key. The purpose, I am only exploring the dimensions of this concept of sentinel of the key is the topic of the talk, by pointing out how this act not only on other institutions, check on other institutions, but check on itself. The purpose of a Bill of Rights is to entrench certain cherished democratic, political, republican values beyond the sway of majoritarian caprice inherent in a democracy. The very purpose of Bill of Rights, said Justice Jackson, was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities, and also to establish them as legal principles to be applied by the courts. One's right to life, liberty, and prosperity, and free, and right to free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. To give them beyond that, because they are the reason is fundamental rights are not conferred rights. Nobody has conferred it upon man, but are inalienable inheritance of man himself. They are above ordinary laws. Ordinary laws cannot change them. They are not built into the law, but are placed above the law. They are not built into the law, but are placed above the law. But then, Bill of Rights is not an automatic assurance of liberty or guarantee of liberty. It depends on the integrity and sensitivity of the institutional mechanism that apply and enforce it. This is the sentinel of KB. These rights are not self-executing. They require human agencies for their effectuation. Courts, lawyers, press, and the whole host of governmental agencies are to implement them. This needs the spirit of constitutionalism more than exhortations in the constitutional document. Conduct of political climate and conducive political climate and tradition, and more than all, the spirit of liberty in the hearts of men. If the spirit of liberty is in the hearts of men, nobody can take it away. If it is not in the hearts of men, nobody can confer it. This is the reality. Earlier, there was a sharp divergence of views on a need for a Bill of Rights, whether they should have a Bill of Rights at all, the fundamental rights as we have in the Part 3 of the Constitution. In the UK, it was also said that a Bill of Rights would create high expectations in the minds of the people and regarded as a panacea for all grievances, which could not in reality be possible to be satisfied in practice. It was also apprehended that a Bill of Rights might promote an activist judiciary, which might hamper strong and progressive government and result in important public issue being discussed and resolved in legal or constitutional terms rather than in moral or political terms. Lord Denning, a great judge himself and a great exponent of liberty, he wrote a beautiful Hamlin Trust Lectures, Freedom Under the Law is a beautiful document. Lord Denning apprehended if judges were given power to overthrow acts of parliament, they would become political. Their appointments would be based on political grounds, and the reputation of our judiciary would suffer accordingly. One has only to see in the great Constitution of the United States of America and India. He said he also criticized the Indian activism of courts. One has only to see the great Constitution of the United States of America and of India, the conflicts which arise from time to time between judges and the legislature. I hope we shall not have such conflicts in this country. Lord Scarman, on the other hand, but Lord Scarman, the pillar of the alternative argument, said, when times are normal and fear is not stalking the land, when times are normal and fear is not stalking the land, English law certainly protects freedom of the individual and respects human personality. But when times are abnormally alive with fear and prejudice, the common law is at a disadvantage. It cannot resist the will, however frightened and prejudiced it may be, of Parliament. The classic illustration, of course, is Regulation 18B and Liversidge versus Anderson. Of course, Liversidge was an embarrassment. Its critics said that it is at best judges' contribution to war effort and is now placed where it belongs, in the War Museum. This is the debate. Ladies and gentlemen, I've taken a lot of your time. I thank you for your patience. The reason and science are the twin principles underpinning and driving forces of Western societies. But assertions of sanctity of ownership and property distorted social outlook. That was one of the early debates in India. Rights to and ownership of property became an obstacle for the reforms and social progress because ownership was not accompanied by corresponding obligations. Ownership of property by itself became a fundamental right. A great debate went on. Then Jamindaris was abolished. The first 10 years of the Supreme Court are replete with cases in which the dominance of the fundamental right to ownership. In fact, in Europe, ownership always went as a philosophical concomitant with reciprocal obligations. And the same Bible on which the property rights were conceptualized has two different effects across the Atlantic. In America, it is different. In Europe, it is different. In fact, in the same St. Augustine said, possession of property is a sin unless it's accompanied by reciprocal obligations. That's it. I will take a few more minutes to convey what I want to say finally. Rights and ownership of property became an obstacle for reforms and social progress, illustrating how sacrifice of social goals at the altar of rule of law make law itself barren and hollow. Rule of law is only a means to an end, not an end in itself. India's long struggle against entrenched property rights without reciprocal obligations is historic. Initially, the court was a mere precedent-ridden court. It was the second stage at which it became an activist court, developing tools for legal control of government. Supreme Court defended democratic institutions and strictly kept in check misuse of power under Article 356 to supersede governments. The case of State of Rajasthan or the Union of India, SR Bombay, etc. are case in point. In the matter of purity of elections, this is a very important area in which the partnership, you can say, a philosophical partnership between the Election Commission of India under Article 324 of the Constitution and the recognition of the amplitude of its powers by the Supreme Court in a series of cases is very, very important exercise. And that is, again, the great role of the sentinel, the Kiwi. In the matter of purity of elections, the contribution of the court is most impressive. In Mohinder Singh Gill case, the court expounded the wide scope of Article 324 and the powers of Election Commission, both express and incidental. In 2019 elections, 43% of the MPs had criminal cases pending against them. Parties were also told to explain why other individuals without such state could not be found. It was also enjoined that information regarding the selected candidates' criminal record be published in vernacular and national newspapers. There are earlier cases brought up before the court by Association of Democratic Reforms, Lok Prahari, etc. Many significant directions are issued from time to time to protect the purity of the electoral process. By some estimates, not official, money spent by the candidates in the 2019 general elections is estimated around 30,000 crores of rupees. Money power is the biggest enemy of democracy, money power in elections. In the area of protection of personal liberty, the activism of the court is most impressive. Death penalty was confined to rarest of rare cases. Equally impressive is the expansion of the concept of access to justice. Lok adalats are another innovation for speedier justice. The records say they have settled over 80 million disputes. But in judicial lawmaking, as described by Roscoe Pound as juristic chemistry, the court does not make or create the raw material, which are the ingredients of the law. The judge collects the existing raw material and combines or recombines them for the purpose the judge intends to achieve. The court cannot create a new raw material. It's only the political department of government, said a scholar, that has the privilege of considering abstract justice and equity. The raw material can only be created or made by the legislature. Ladies and gentlemen, the increased functions of the state have changed its concept as an instrument of power into an agency of society. The greatest of these concerns that have so far transformed the state, it was increasingly regarded as a proper function or even an obligation of government to ward off distress and strain, not only among the poor, but amongst all citizens of society. The institutional outcome of the assumption the institutional outcome of the assumption by a society of legal and therefore formal and explicit responsibility for the basic well-being of all the members. Such a state emerges when a society or decision-making groups become convinced that the welfare of the individual is too important to be left to custom or to informal arrangements and private understanding, and therefore a concern of the government. But the greatest danger, I conclude with this statement, but the greatest danger to constitutionalism and constitutional government in emergent democracies and developing countries arises from the human factor in public life to distort and vitiate whatever government forms may be devised, governmental forms may be devised. However carefully the institutional forms may have been constructed, much will turn upon the actual behavior of individuals and their willingness to observe the rules. In a classic analysis of the problem in a book called Constitutionalism in Emergent States, a scholar says, and I quote, "We have seen how political corruption and the waste and inefficiency which it endangers have undermined the ability of the government to secure the welfare of the people, tainting the state in the public eye as an instrument of plunder and thereby alienating the people's loyalty. How tribal politics has, like a canker, eaten into the body politic, sapping its vital energies and the entire fabric of society, pitching tribe against tribe in mutual antagonism, making impossible the development of a national spirit." That's why Qureshi, former chief election commissioner himself, spoke of the politician-bureaucrat nexus in recovering the investment made in the elections by the candidate. And it says where the corruption, and that is where he says corruption begins. He said elections are polarizing events which have accentuated casteism, communalism, corruption, and crony capitalism. These are the things that he said. Ultimately, underlying it all is the basic legitimacy of the judicial process. An American lawyer said this, and I quote, "The wisdom and moral force of great judges, past and present, make their contribution. Procedural fairness and regularity are also essential to legitimacy. Procedural fairness and regularity are also essential to legitimacy. In the constitutional sphere, law has long drawn strength from traditional and evocative precepts that symbolize the historic struggles for freedom and government operation. It is rightly said that history of liberty is the history of procedure. The creative role of the American Supreme Court has been one of great public satisfactions, and it is acclaimed. Speaking of the American Supreme Court, a scholar said, "The final judgment of the American people will unquestionably be that their constitutional rights are safe in the hands of the federal judiciary. Throughout the whole history of the United States, it furnishes the highest example of adequate results of any branch of government. It has averted many a storm which has threatened our peace and has lent its powerful aid in uniting the whole country in the bonds of justice." It can truly be said of the Indian Supreme Court as well. It is a trusted sentinel of the QEB. Thank you very much for your patience and courtesy. Thank you.